That guy came back, making all this, he's retired, chilling. So the other guy took his spot.
Took his spot.
So he come, he had a hearing out here Friday. He said he couldn't stop shaking the whole weekend.
Session. Honorable Elizabeth Chair, preside and be seated and remain quiet, please.
Okay, good afternoon. Court's in session. The defendant is present. The attorneys are present. And we're here for a status on the Daubert hearing that was scheduled for Monday, which I understand is no longer necessary because the defense is withdrawing the witnesses that the state was objecting to. Is that correct?
We're not relying on those the specific things outlined in the state's Daubert hearing. So that's why the hearing is no longer necessary, because we're not relying on those types of scans or comparisons.
That the state was objecting to.
That's correct, yes, ma'am.
State, are you in agreement with that?
Judge, yes, and just for the record, it's the neuroquant, the diffusion tensor imaging, which is DTI, quantitative EEG, and the MIM neuro. That was the basis of the state's motion to exclude under Daubert. We received an email Sunday night from the defense that they no longer intend to rely on any of that evidence in their mitigation presentation. So obviously there's no need to go forward with the hearing. We would ask, however, that the court colloquy the defendant on this issue, and that it was a strategic decision by the defense, and that the defendant is in agreement.
Okay, do you all have some type of an agreed order prepared so that we can have documentation in the file that this is no longer, that these scientific issues are no longer a point of contention?
I will prepare something, Judge. And in addition, we have filed another Daubert regarding a chart that was used in Dr. Paul Connor's PowerPoint. It was a chart comparing 30 other capital defendants as they were diagnosed with various forms of FASD. We challenged the methodology that chart was put together under, and that is also being no longer relied upon by the defense per an email from Mr. Support.
Okay, so when you all prepare some type of an agreed order, I'll sign it and I will colloquy the defendant at that time.
There's like a blinding light right in our face. I'm just trying to move these things.
That's okay.
Thank you.
All right, so we did have the rest of the week set aside for these evidentiary issues. Is there anything else that can be handled this week? Otherwise, they're going to be using the courtroom for other things.
Well, the other thing that's pending before the court is the state's motion to compel on the depositions of Richard Moore and Zachary Cruz. The state filed a reply last week. There was our initial motion. The attorneys representing Mr. Moore and Mr. Cruz responded to that with a memorandum, and then we responded with a reply to that memorandum in which we asked the court to make a decision without a hearing. We feel that the court could rule on the pleadings.
Okay, I'll have that to you by the end of the week.
Okay. There was originally maybe something to talk about hearing at 7:30 tomorrow morning. Is that no longer necessary?
I don't know, you tell me.
Well, the attorney is fine. She's en route from Virginia right now. So she will be here in the morning, is my understanding.
Okay, so then, but if we're not having the Daubert hearing, we don't need to do it at 7:30, we can do it at 9. Can you relay the message?
Yes?
Please, will you relay the message?
Yes.
Okay, other than the state's motion to compel, which if she's going to be here, I'll hold off on issuing an order until I hear what, if anything, she has to say that's relevant. And is there anything else that we need to set for this week, or we're good to go for Monday, the 22nd, for the completion or the start of the defense case?
If I may?
Sure.
We have the issue of the objections that were made during the perpetuation of Ms. Vinay Browd's testimony. It was, I can't remember when it was, a couple weeks ago. And we have the transcript, which we can provide to Your Honor, obviously. And then I think Mr. Marcus and I just have various arguments to make based on the content of Ms. Browd's perpetuated testimony.
I'm sorry, repeat the last part of what you just said, please.
Mr. Marcus and I just have some arguments about the objections that were made during the course of Ms. Browd's perpetuated testimony.
Okay, so I saw that there's two zip drives here, and one is the testimony of Ms. Browd. So I'll review this afternoon, and then you all can make your arguments tomorrow after the lawyer for Mr. Zachary Cruz makes her points at 9 o'clock. Is that okay?
That's
fine. It would be
fine.
better if I...
Judge, you can do as you like. I don't think it'll take us very long to go through the transcript with you.
Okay.
It is we don't have to go through every page as far as I'm concerned. Just go to the objections.
Okay.
I don't think you need to watch the whole thing.
You don't? Okay, so...
But if you want to,
No.
please feel free.
Sure.
There's a number of objections I'm going to withdraw, so that'll save time, and then we can get down to the ones that we're going to continue to disagree until you're ruling.
So we'll argue this issue tomorrow. You all will argue, and I will hear this issue tomorrow. But what you're saying is I don't need to listen to the whole deposition in order to be able to rule on the issues.
That's my opinion.
Okay.
Yeah, I mean, it's obviously it's entirely up to you, Your Honor.
Okay.
Some of it might require a little bit of context. But
Okay.
I think Mr. Marcus is right. I have noted 16 total issues that I wanted to raise. Some of them don't exist. I don't think it'll be any more than that.
Okay, and then you said there's a transcript.
Yeah, if you don't have it, I will get it to you.
Is it? I have two, feels like zip drives with a note that someone from your office dropped these off to me, but it says it's the copy of the video of the testimony of Ms. Browd.
Yes, ma'am.
And I assume that means the digital,
It
not
should
the
be.
transcript?
It should be a video and a transcript, but I will make sure that you get it if it's not on.
Okay, well, I'll look at them. I just got them this morning.
Thank you.
Thank you. Is there anything else? I have a number of documents on my desk, some of which were received this morning. Actually, it looks like last Wednesday, and some of which were received more recently, and I don't know which ones are moot, so I'm just going to let you all tell me what needs to be heard and what doesn't.
Could you read out what you have in front of you?
Sure. I have the perpetuated testimony. I think the rest of it goes to the Doward issues. Motion to strike state witness.
I think we should have an order for the court by the end of court today.
An agreed
Reference
order?
to that issue, yes.
Okay, let me put that down. Thank you. So I assume the amended exhibits to motion to strike state witness would go with the motion to strike state witness that you're going to have an agreed order on?
Yes, ma'am.
Okay. It looks like the rest of it is pertinent to the Daubert hearing that we're no longer having.
And then there should be one other thing related to the motion to strike the witness on the same witness, Judge.
Do you have you want to tell me the pleading number or the, if you don't mind, or you all can just come have a look at what's sitting here if you want.
I think it's 326, D 326.
I've got it, motion for protective order, and that relates to the same motion. Motion for protective order?
We're going to have something for the court as well on that.
Just as another loose end, we're not quite finished, but the state, if you recall, as we were leaving court last time, wanted to withdraw certain exhibits.
Right.
And we're just working on the final, I just gave transcripts to the defense. And,
The final list of what you're going to ask to withdraw?
yeah, actually as a court exhibit, to move it as a state's exhibit to a court exhibit, not for the jury.
So for purposes of appeal, and then I had indicated that I would fashion some type of jury instruction telling the jurors that in the event that they've kept track of every single number and they're looking for numbers, whatever they are, 5, 7, 9, by way of an example, that those are not for their consideration. They shouldn't spend any time looking for those. Something to that effect.
Thank you.
Judge, we have a half day on the 25th, which is Thursday. Could you just, what's a half day for the court, just so we can schedule our afternoon?
Okay, so I obviously didn't realize that this week was going to be off. If you want to make it a full day, we can make that a full day. I thought that we were going to be in hearings this entire week, full days, meaning 9 to 5, and that perhaps the lawyers would need some time to regroup, but it can be whatever, although I've already told the jurors. So I would say it can be till 1 o'clock, or we can make it a full day, whatever your preference is.
1 o'clock is fine.
Okay?
And then we'll be submitting our motion for JOA
Okay.
in writing. And
Okay.
we just ask if, in the event that we need to make any argument, if we could just have 30 minutes on Monday morning.
Sure.
And we will have it to the state by Friday.
Okay, and then also, I signed the order to transport your witness from, I believe, Dade County to
Okay.
Broward County. I know that you said there were some issues with that person coming to court on the 22nd. If you need me to resolve any issues, in other words, place a call to the sheriff's office to make sure the witness is here.
We're good.
Okay. I did read in the paper that maybe the issue of her going to trial was not an issue anymore. I don't know if it is or not, but that the lawyers were moving to withdraw from her case and there was things pending other than a trial, so I don't know if that resolved it or not.
We're good.
Okay.
So what time do you want us here on, oh, I'm sorry, we have court tomorrow, but for Monday, what time do you want to start on Monday?
If we can start at 9 o'clock, that would be great. And then when we finish this, I need to speak to the lawyer's side, but I'd rather do it up at the bench. And it doesn't have to be all the lawyers, if I can just have two from each side, or you all can come up, that's fine.
No?
If there's nothing else.
I don't think there's anything.
Okay,
We just need to prepare those orders for the court.
sure. I'm going in there. Okay. Miss Curtis, why don't you come? Recess, and I'll just, if you all are going to prepare those orders now, I'll just wait for them. Other than that, I'll see you tomorrow morning at 9. Okay? Thank you.
Well, Judge, can we keep you here just for the order in case we have any issues with the order?
Yes, I'm going to stay here working on, I'm going to be reviewing things and stay here until you have it.
I apologize.
That's okay.